Okay.
So anyhow, because it's always a fun time. We always do things. We tend to do and be fun and all that kind of stuff. So anyhow, hey, out there in spray wash land, we're going to get ready to go here pretty soon, and we're going to talk a little bit about branding today, and that should be a fun discussion. And I do want to bring up that some of this is coming through from Landon, and I'm thinking he'll join us today, and we'll get into some different topics and different things, and we'll kind of go over all kinds of stuff. But our special guest today, and I'm going to ask you a question just so you know that I haven't prepped you for, and okay. I'm going to see how you answer it and see if you get the answer right. I just want you to know that this is a test. Okay. So, Mr. Roland here. So let me see if I get your last name right. Sennholz. Is that right?
Good.
Okay. So it's Roland Sennholz, Esquire. Okay. So you tell me what Esquire means.
Esquire means that you are licensed to practice law somewhere in the United States.
That's not the answer I was looking for. I'm sorry you got it wrong.
Okay.
So Esquire also could mean, right? How does it go? It's that you're training for knighthood. Did you know that? Esquire.
Oh, okay.
So I was hoping that you were training for knighthood.
Yeah, that's what the show was about. It's not about this legal stuff, but anyway.
Well, I mean, my name is Roland. I'm Charlemagne's right-hand man was named Roland. There might be something going on there.
There you go. So, Mr. Roland, tell us a little bit about you and the company that you work for and what it is that your company does. And then we're going to get in. We're going to start talking about branding. So tell us a little bit about yourself.
Okay. Yeah. So my name is Roland Sennholz. I work at Argent Place Law, which is a law firm in Falls Church, Virginia. We're basically Northern Virginia, just outside of DC. And we help entrepreneurs with basically all of their red tape. When you get a business started, you're going to need probably an LLC. You're going to need some contracts, maybe a trademark, probably a trademark. That's what we're here to talk about tonight. Mm-hmm. And just some other random paperwork and industry-specific questions. And so it really helps to have someone who can actually listen to what you're talking about, listen to what you're doing, and then give advice on what to do to not break the law and maybe even prosper and succeed along the way. So we help with all of that. And I've been working with the firm, I think we're past 4 years at this point, and just helping entrepreneurs with all kinds of things. So I have helped people start everything from a preschool to a whole bunch of government contractors and speaking kinds of businesses, a couple tech companies, one whiskey distillery. That was kind of fun. And just a bunch of different companies. So looking forward to it today.
Well, and one of the things I can tell you right now, you'll get lots of questions probably. And the first question that I saw right off the bat is something that I intended to cover anyhow. And this is coming from Matt Matheson, who is saying, so if someone used a picture that they stole in an ad, can you sue for income generated during the time the ad was ran?
Well, it's going to depend on a couple of things. And actually, okay, so before I start answering all the questions, I do want to add my own star.
Legal disclaimer.
Yes, disclaimer. I love disclaimers because that's part of my job description. So I am a lawyer. I am not your lawyer. You may want to consult with a legal professional on the specific facts of your case before you just kind of take what I'm saying and go run with it. And
you're doing a generalized thing, not a honed in thing on your particular problem.
Yes.
And none of you are clients.
Right. I'm going to try and answer in broad strokes rather than in just like this one specific case. Mm-hmm. Generally speaking, so a picture, if someone used a picture that they stole in an ad, a picture that they stole. So I'm assuming then that you own the picture, right? You have a copyright to it. You have registered that copyright with the U.S. Copyright Office.
That's the question.
Okay, that's the question. do you actually own the picture, right? If someone else steals your picture, then and you own that picture, then there are a couple of different kinds of damages you can pursue. One of them probably is the income generated during the time the ad was run, but there's also a thing called statutory damages, which is how they nail people who take music and then they post it on Facebook or whatever. Every time someone listens to that song, if you've like stolen a song and put it online, that's one infringement. And the statutory damages that you can get for copyright infringement are up to $150,000 per infringement. Okay, so they don't mess around when it comes to copyright infringement.
But does that have to be something that you filed a copyright on, or go ahead?
So copyright is one of these rights that's kind of you get it when you create the work. Technically, you own copyright in something as soon as you create it. But in order to actually get those statutory damages that I was talking about, you want to have registered the copyright either before the infringement took place or within a pretty short window after it took place. Mm-hmm. So you have to have it registered if you really want to do the most you can with it.
Mm-hmm.
We had a very well-known picture that we used for years, and it was on the rear of all of our trucks. And I went ahead and took the steps of getting that picture copyrighted. And it's ironic now. I go out and I'll do a reverse image search, and I find where this photo has been used literally hundreds of times by people that are not me. And I've always wondered, would that be a fun retirement program of just because, I mean, I've got the copyright, number on those two, and it's not just one, but it's two separate images because it's a before and an after taken at separate times. I was thinking, man, I could just bang this out for $300,000 a pop from everybody.
Well, maybe, but here's the thing: you're gonna be running how many lawsuits for how many years?
Yeah, exactly.
With people that have no money, probably.
Yeah, true. They didn't have enough business to take their own damn pictures. Yeah.
And that's the other piece of it, right? Like, okay.
So let me ask you this: what if you put a watermark on the photos? And let me make it a two-part question. What if you put a watermark on the photos, one, and then number two, what if they remove your watermark from the photos?
Well, neither of those. Okay, so if you have a watermark on the photo, right, and then they copy it, so the watermark pretty much just makes it easier to prove that they copied your photo, right? If the one that they have has the same watermark as you, then it's pretty clear, it's pretty obvious that, okay, they got it from here. If they go in and they alter, manipulate, remove the watermark, then if you can prove that they did that, that doesn't necessarily affect whether it affects damages, right? It affects like, okay, this person didn't just steal the picture. They knowingly stole the picture and then tried to cover it up.
Right now, it's almost like a malicious intent kind of thing.
Exactly. It goes to show that they weren't just kind of like, oh, let me download a random picture off the internet. They actually went and stole something and then tried to make.
Ironically, we've seen this in this industry. We've actually seen this more times than I really care to admit from some of my people, not my people, but people that are in this industry where, oh, that's a great looking picture. I'm just going to crop out this top corner or bottom corner that has the logo on it, which is just horrific, to do. I mean, it's one thing to go and steal a picture, but it's really, really bad whenever you go and take someone's watermark logo out of the picture and use it.
Yeah, exactly.
So here's a legal question.
To the random comment here that asks if I'm Jared Kushner. No, I'm not Jared Kushner. I did get that about once a week back when he was in office, before COVID anyway. But yes, I know there's an uncanny resemblance. thanks / sorry /
We
whatever.
paid him to say he's not Jared, just so you know. We paid him to say he's not Jared.
Well, Jared's not doing a lot these days, so what steps do I need to do to switch a DBA to an LLC, and what benefits would there be?
Okay. I'm going to try and answer that quickly because there is one more thing on the whole before and after picture, or I'm assuming they're before and after picture.
We can come back. We can readdress this.
Either way.
Okay. I was going to say we can just come back to that, but okay. So I'm assuming there that it was like before and after pictures or something like that, not a branding item, right? It was not like your logo. It was not a picture that you use to advertise your services. Like, this picture is synonymous with my company. It was more kind of a results thing, right? That's where.
But he did use it in advertising because it was on the back of his trucks, and he used it in advertising forms.
Sure. Okay. Okay. Copyright is a good way to protect pictures, other things of artistic books, right? Artistic expression is what it's supposed to protect. Trademark is supposed to protect logos, names, brands, anything that is kind of synonymous with your company. Okay, so you could trademark a picture. If you use it as advertising on the back of your truck, you could totally trademark it. You're going to get different. It's going to be easier or harder to protect one image or another depending on what it is what I'm trying to say. Don't assume that because it's like a before and after picture, it must be copyright. Don't assume that because it's a logo, it must be trademark. It also depends on kind of what you're trying to accomplish with it.
Hold on. You just reminded me of something. I looked over and said, an idea here. So this is a device that we use in our industry called the proportioner. And I know that the inventor has trademarked this logo. He has trademarked this logo right here. The proportioner trademarked the name, and then has also filed for patent protection on the process of this whole box. So he's taken multiple steps on there to really lock up both the name, the box, and the process of doing it, and the artwork.
Would you like me to do like a really brief summary of patent, trademark, copyright, and kind of what the differences are?
Sure. You're the boss. Run with it.
Well, okay, because we're talking about brand protection, right? Patents are a little bit outside of that, but since we're talking IP anyway, there are really kind of four main pieces of intellectual property. Okay, there are patents, which are designed to protect something that is functional, right? It is a method of doing something. It is a design. It is it's a device of some kind, usually. Right? Could be a box that has valves and specific things inside of it to make it work a certain way. Could be a smartphone. Could be whatever, as long as it does something. Earlier today, I was dealing with a client who has a patent on one of those baby backpacks, right? Where you can carry your baby around. And so it's a device, right? It's designed a certain way, and the design of the device makes it useful for a certain function, which you can protect through patent. Copyright is designed to protect, the legalese is an artistic expression fixed in a tangible medium. Okay, so the idea is you have something that requires a bare minimum of creativity. Something that requires a bare minimum of creativity. Could be a song, could be a picture, could be a movie, could be code, software code, could be whatever, but it requires a bare minimum of creativity, and it is actually fixed in a tangible, it exists somewhere outside the person's head. So that, for example, there was a copyright case a while back where a fellow sued, I think it was George Lucas or Lucasfilms, whatever. He sued them basically saying, oh yeah, the AT-AT walkers in Star Wars, right? The big four-legged things, tanks with the lasers on the nose. Those are actually a copy of my Garthian Striders that I came up with several years before the Star Wars movies ever came out. And basically the trial, to boil it all down to one or two sentences, the trial went something like this. Great, do you have any proof that you came up with that before Star Wars? Well, I had some documents, but they were destroyed. So no. Yeah, no, not really. Okay, dismissed.
Pretty quick and easy.
So the copyright can't just be for like, oh yeah, I had an idea for a story about a super detective. You have to write it down. It's like, okay, his name's Sherlock Holmes. He did X, Y, and Z. These are his adventures. Now you get the copyright protection. You can't copyright a title. Yeah, you can't copyright a title. It's too short. Usually, there's not enough information. But you can copyright usually a picture. You can copyright a bunch of different things. There was a lawsuit pretty recently about what happens if like who owns the copyright. So there was a chimpanzee that got a camera away from a photographer and ended up accidentally taking a selfie. And the question was, who owns the copyright? It wasn't taken by a human. So there were a lot of weird and interesting questions that come up here, but they're more interesting to people who like to basically build Legos in their mind than to other people sometimes. So I'm going to
Get into all that.
And I probably could answer that because in Florida, pigs have constitutional rights as agreed upon by our voters back 20 years ago. So I have a feeling in Florida, the chimpanzee would own that.
Interesting.
It must be state constitution.
Is that Florida?
No,
Is that California?
It's our state constitution.
Okay.
Whenever voters want to do something in Florida and they can't get, and unfortunately they just make a constitutional amendment to it. So our constitution is just rife with ridiculous. When they couldn't get marijuana laws passed, they changed the constitution. When they wanted, they thought that the way pigs were raised were cruel. They literally gave pigs rights, or I shouldn't say they gave them rights, but ostensibly gave them rights because they regulated the way that pigs had to be raised, named in the Florida Constitution. It's really kind of goofy.
So let's go back to that question you had, Ray.
What's that?
The one that was on the side.
The LLC. The
LLC question. Let's go back.
And then we'll get into some of Landon's questions.
Yeah. What steps do I need to switch my DBA to an LLC?
And what's the
did I drop out? Can you still hear me?
No, you're there.
Okay. My video dropped for a second. So to switch your DBA to an LLC. So a DBA is okay. I'm trying to figure out whether to answer the question you asked me or the question I think you're really asking. So when you start a company, if you don't register with the state, okay, it is what we call a proprietorship, right? At least for IRS tax purposes, it is a proprietorship. It is basically kind of an extension.
There is no DBA. There's no entity. Right. There is no DBA because you don't have a business. In order to have a DBA, you've got to be a company, corporation, or an LLC to do a DBA. Is that where you're at?
So you can have a DBA. So if you are operating a business under a name and the name, and you don't have an entity, but you just are using that name, then that is a DBA. It just kind of points back to you. Mm-hmm. Okay. Normally when I think of a DBA, I think of you have an LLC, you have something registered with the state, and then you want to rebrand or you want to open a second line of business under the same LLC, but have it have a different name, right?
So I can give you an example. Whenever we sold our company, Spray Wash Exterior Cleaning, we actually then changed the name of that corporation, did a legal name change to RT Burke Consulting, which is my wife and my initials on there. And then we have a separate DBA as Power Wash Store Tallahassee on there.
There we go. So I think of a DBA as kind of like a desktop shortcut, right, on a computer, or a pointer, right, like a it refers to something else. Okay, and so a DBA is kind of usually it's something you file with the state. Sometimes it's something you file with the county. It depends on what state you're in, but it's something that kind of serves to let the state know that this is another official name for this same company.
Mm-hmm.
Usually where I see people requesting a DBA or needing a DBA is if they're going to start a second completely separate line of business in the same company, or if they are trying to take payments under that DBA, under that trade name, and their bank requests, hey, can you prove to us that that name actually corresponds to your LLC?
We just ran into that where we had to go because we're getting checks into Power Wash Store Tallahassee, and we go to deposit them, and they're like, well, your account says RT Burke Consulting.
There we go. Yep. And bank lawyers are like that. They want to be sure that everything is on the line.
Could I get you
the way it's supposed to be?
To speak
Yes,
then to
exactly.
the other end of this question. So, but basically, so if you're just doing a DBA without an LLC or without any type of the corporate, just a sole proprietorship.
Yep.
Could you speak to just how you literally have no protections and you are liable probably for lots of horrible bad things that could happen? And what is this protection that an LLC does for you?
Why incorporate? Yeah. Okay. So it goes back to liability. Okay. Let's say that something happens while you're on the job. You're pressure washing and some idiot sticks his hand right in front of the nozzle. You're whatever, you're doing something and someone gets hurt. Okay. They now bring a lawsuit against the person who hurt them. Right. Okay. I guess we'll run with my example. They stick their hand in front of the nozzle. You hurt them because you weren't careful enough to make sure that they didn't put their hand in front of the nozzle, and therefore you were negligent. Dumber arguments have been made. So they say, you're negligent and you owe me millions of dollars because I'm missing all my fingers now. Whatever. The lawsuit then proceeds, and the jury says, for whatever reason, yeah, we agree. You owe that person millions of dollars for the harm that they came to because of this accident. Now, here we come to the fork in the road. If who this person sued is you personally because you were using a DBA, right? It was a proprietorship. It was basically just another name for you. Then they're suing you personally, and everything that you own is now something that they can come after for that judgment, for that debt, right? For the lawsuit. When you win a lawsuit and you get a monetary award, it's called a judgment. So they can come after you for that judgment, and anything and everything you own, your home, your car, your pets, whatever. Well, maybe in some states, unless they have constitutional rights, like pigs in Florida, or whatever. But they can come after your property for to satisfy that judgment, right? If, on the other hand, we could take the other fork in the road. Let's say that you incorporated before this accident happened. Well, now you weren't really there pressure washing as you. You were there pressure washing as kind of an extension, an agent, right, of the LLC. You were there on behalf of the company. which means that the responsible person is not you, it's the company. And then they can go after the company, or they would have to go after the company. Most of the time, it is not possible to go after the person who owns a company. It's only possible to go after the company. Unless you can prove fraud or something else pretty serious, you can only go after the company, not the person, not the owner.
Well, let me ask you this then, because my attorney scolded me pretty hardcore on piercing the corporate veil. And I think a lot of small business owners are very, very guilty of doing this. Of my business checking account is also my personal piggy bank, and I'm out doing, okay, I need money here. Let me just go to the business account because I haven't paid myself a check. And so now I've got a record of financial things, and I'm buying myself a lot of personal stuff on my business account. So that is now what we're calling piercing the corporate veil. Is that the terminology I'm hearing there?
That is the terminology. Yep. So piercing the corporate veil is the term for what happens when you sue the owner of the company and you try to say, well, the company isn't really, it's a sham company kind of. It's there to
shield you,
to let them do stuff without any consequence, rather than actually being a legitimate company. And there are a couple of things that you usually use to try and prove that. And you just named one of the top 3 mistakes that I see entrepreneurs make. And that is that they don't treat the company like a separate entity, a separate person, basically. When you have an LLC, right, it provides this wonderful protection because let's say that they get a judgment against the LLC, they can only fulfill that judgment with the LLC's assets. If the LLC runs out of money, then too bad, the rest of their judgment goes unpaid, goes unfulfilled. They can't come after your house or your car or your pet or whatever unless those are owned by the company too.
And there's where the problem is if you keep all of your stuff in the name of the company.
And so to go back to the piercing the corporate veil question, the top 3 mistakes, sometimes we see entrepreneurs who have a company, right? They have an LLC, and they maybe even and they either don't set up a separate bank account for the LLC. They just use their own personal account, or they do set up a separate account, but then they don't keep the wall there. They don't keep it separate from their personal stuff. They use the company money to pay personal debts, or they use personal money to cover. They don't carefully, they don't ask, like, okay.
They're commingling. They're commingling their funds.
Yes, the technical term is commingling.
They're writing a personal check, let's say, to the power wash store instead of a company check to the power wash store. When what they should do is write a personal check to the company and then let the company write the check to, and then that way they can show it as a loan to the company, and then the company makes the payment to the power wash.
Or I go out for a really nice dinner and I can't prove that we've actually discussed business, or I've taken other pressure washers or customers out to that dinner, and it really turns out that it's just me and my wife going out there doing it.
Well, although, that one's a little bit, that's up to your tax professional a little bit, because I know that let's say that, I don't know if it sounds like you and your wife are in business together.
Right. Well, yeah, it's a little bit. I'm not a good example of that, but
okay.
Yeah.
Well, what I mean is, if you go out to dinner with your wife and you at least talk some business, now it could be a business expense, right? It could potentially.
Check with your tax professional.
The rules, yes, check with your tax professional, because the rules around meals, especially, are fast moving. They change often. Before COVID, it was like, I think when Trump came into office, they actually reduced the amount of stuff that you could do on meals and entertainment. Then COVID happened, and then they said, you know what, we need to save the restaurants. Let's make meals deductible again. And so they changed it back, and I don't know where it is now. So check with your tax professional, because those rules change quickly.
All right, let's head back towards the branding side, because that's what we're supposed to be talking about. This is common for us. We don't necessarily follow our forum every time. So I want to get into a couple questions that Landon had asked and thoughts that he had brought out. And I think that they were really good. And I think they're things we should talk about when you look at the branding side of things. So one of the things that Landon said was, if you want to name your business the same as another business, don't do that. Okay. Choose another name. If you take a name thinking it's not a big deal because of geography, so let's say you're in Alaska and they're in Florida, that's still not a good thing. So because of geography, you're wrong. It's a big deal. Google will populate all names. There is a specific search. Let's see. The customer is left to call the wrong business or discern what business is which one. Okay, so if you're naming it I'm just going to pick on the Power Wash store. So if you're calling it the Power Wash store, and there weren't all the franchises and all that, but there were a Power Wash store that started in Milwaukee, but then another one decided, hey, I like that name. I'm going to take it because it's available in the state of Alaska. That's a bad thing to do. What do you think about that?
It is kind of a bad idea. So trademarks are, generally speaking, right, you want to get a federal trademark if you can. Okay, a federal trademark is a lot stronger than not having a trademark at all, and it's even stronger than having a state trademark. So a federal trademark protects you anywhere in the U.S. Even if you are in Alaska and the other person is operating in Florida, then theoretically there's a collision there. If one of them owns a trademark, then he can ask the other one to change names. Could you actually force that in a lawsuit if you were to really have a knockdown, drag out fight about it? That one's a little bit iffy. It's going to depend on the facts, but generally, but you could at least make a demand, right? You could at least say, hey, you're using my name, knock it off. And in fact, a trademark gives you a couple of things that you can do that not everyone knows about. Okay, so one of my favorite things to do when I'm sending someone a cease and desist letter, hey, you're using our client's trademark. I understand that neither you nor my client wants there to be customer confusion. We don't want your customers going to the wrong people. You don't want your customers going to the wrong people. But here in this particular instance, my client actually has a federally registered trademark. So would you please be the one to change your name? Or else I will submit takedown requests and ask Facebook, Instagram, Twitter, and everyone else.
Everybody else shut you down.
Yeah. Because that's something you can do. That's something you can do with a federal trademark. You can basically submit requests to Facebook, Instagram, whoever you want, any of the big platforms, and say, this content infringes my trademark, please remove it.
What about doing that? That could potentially be more devastating than a lawsuit, really.
Yeah, you're just all
that's why I use it, is because you threaten to sue someone, and they're like, that's going to cost at least $10,000 just to get the ball rolling. Let's see if they're bluffing.
But it's not going to cost that to send all the things out for the.
So exactly. There was a guy who was making knockoffs of these, and he literally named his business Fred's Proportioners, and it's not really Fred's Proportioners. I'm not going to give him the credit on doing that. And it's like, you understand that there's a trademark on this name out here, a copyright and trademarks on there, and you named your knockoff invention Fred's Proportioners. And this could really, really wind out badly for you. And he's like, oh, no. See, that says proportioner, and mine has an S on the end of it, so it'll be okay.
Then what? Right. So
and I'm just thinking, these guys play in And unfortunately, it's kind of like you can't get blood from a turnip, and you can't sue. What am I going to get? A 1976 Chevelle with painted 4 different colors, and like a 1989 F-150 work truck, which is probably what I'm dealing with here. But you can't get blood from a turnip. So, but there's a lot of guys that make really bad mistakes and really bad legal decisions out there, not realizing what they could actually cost themselves or their families.
And on something like that, shutting them down Facebook wise and all that, it would be a heck of a lot easier to do than going after them, on the legal realm of it. So another thing he says is a customer attempted to tag his business name when writing a testimonial on their Facebook page. They ended up mistakenly tagging another company that had taken that name, even though it was across the country. This is where, and the reason that Facebook and them will take that seriously and you can then apply to, if you have that trademark, and apply it to Facebook and Instagram and all that to get it taken down. That's what you're saying.
Okay, so let's see. I want to answer the previous question. There was a question. Dang it, what was the question before this one? Okay.
Did we confuse you?
Okay. I'm sorry. I guess I got my brain went somewhere else for a second. So let's see. Yeah, okay. Let's question again, please.
All right. So this question was about if you have your business name in another state, and then somebody else puts it in wherever their state is at, and then you had said something about Facebook and Instagram and Twitter and all that. That's probably the better route than it is to go after them on the legal route, because if they're in 2 different areas, and as I understand it, part of the reasoning behind all this is that you have to be able to prove that they're somehow damaging you as well. And if they can't damage you because they're pressure washing in Alaska, how are they damaging you in Florida? Well, because I had somebody trying to tag me in Florida. So that kind of thing, I guess, is where that could be confusing.
So this is I'm giving away a little bit of my secret sauce here, because that's exactly it. I've realized my background, right? I grew up in a business. My parents owned a publishing company. I now own an e-commerce company. I have enough businessman in me to look at this and go, threatening a lawsuit really is not the most efficient way to do this. It's really not the most efficient way to get someone who is using your name to stop. If you threaten, on the other hand, threaten on the other hand to take down their Facebook page, their Instagram, their Twitter, whatever, you do all that. That is more bang for your buck. It hits them harder, honestly, than a lawsuit might, and it's less expensive. It's way less expensive.
Oh, I mean, think about it, Doug. I mean, what would happen? Anybody out here listening? What would literally happen if all of a sudden your Google My Business reviews got reduced to nothing overnight?
All of it.
Because they took your
Google My Business got wiped out, your Facebook got wiped out, your Twitter account got wiped out. All of those things got wiped out. You're out of business. And I would wonder, so if you could move in with the Verizon, let's say they've got a Verizon phone account and they're answering it as in, Power Wash store. But so I wonder how that would work.
That's okay. Probably not that. You can't control what they say over the phone. That's a little bit too far out. But if, and I don't know if it's possible to actually have Google delist things. I don't know if you can do that. I know you could follow the Google links, right? You could search for them and say, okay, they have a listing on Yelp, they have a listing on here, they have a listing on there, and then you could submit takedowns to all of those. I don't know how cost effective that is. I tend to aim for the top 2 or 3 because that's where you get the most bang for your buck. And I am still billing for my time to do that, right? Okay, it's 15 minutes for me to submit a takedown request instead of however many hours to put together a trademark complaint and then file it. But
Well, I'll tell you one thing that I found that Google did that was they're take very seriously. Whenever you are using copyrighted artwork to go and link to like the copyrighted artwork of maybe something like this to go and link to a competitor's product, and you actually have like the literally the trademark technical drawings on there, and you are using that to go and link it to your another place. Both Google and Facebook take that extremely seriously, and will come down upon you like the hammer of Thor.
Which is
okay. I haven't heard about. I haven't heard any stories of they're doing that on their own. I haven't heard any stories. They were
notified. They were notified with a lawyer letter that, hey, this person has this link that is being fought over here using this drawing. Here's the trademark number. Here's the copyright number, and you need to check this link out. And they very rapidly responded to that within days, like quicker than I've ever seen Google respond to anything.
Oh, Google. I mean, so the way that it works is if you report something as a trademark infringement and they fail to do something about it, now they are also infringing the trademark.
Mm-hmm. They become liable.
I mean, I almost sued Instagram once for this. As it turned out, we had a client who he had a logo, right? He had a name of his company that was trademarked. It wasn't pressure washing, but I think it was actually in construction. He had the name of his company was trademarked. Someone had a Facebook page and an Instagram page for their company that had the same name. I submitted a takedown request on Facebook, and it went down. No problem, no question, no issue, no nothing. They didn't even fight back. They were just like, yep, taken down. Then I submit it with Instagram, and Instagram comes back and says, yeah, this, what did they say? The page doesn't even use the logo. I'm like, I didn't submit a logo, I did a word mark. And then a couple days later, different person comes back. Clearly the first person made a mistake. Different person comes back and says, oh yeah, it looks like this other person has been using the trademark since before you have, and so we don't have to take it down. So the second person, Enrique, the intellectual property specialist, who I guarantee you was not a lawyer, came back and basically said, well, we don't have to take it down. And he's correct, sort of, okay? When two trademarks fight, the one that was used first wins.
That's actually a specific question I had.
Generally speaking, when two trademarks fight, the one that was used first wins. You have to be able to prove that you used yours first, but the one that was used first. In fact, that's part of every trademark application. You have to list the date of first use.
So don't mean to interrupt you there, but I have one that's very specific where a gentleman bought, and he's somebody that frequents here, so he might be on here. But a gentleman bought a company, okay, and then he's operating as this company. And then he gets served a cease and desist, if you would, over the company name. So the company that served the cease and desist had gotten a trademark on the company name. However, the company that this guy purchased was in business before the first company.
Yep.
So it got a little sticky.
Well, and that's where having a good trademark lawyer will help you, because the trademark lawyer can then look at the situation and say, do they have a shot? Do they have some ability to mess with you? And then at the very least they can negotiate, right? They can actually. Okay, so I'm going to run with that a little bit. I have a client who he started using his name first. Some company up in New York came up with the name later and filed for a trademark on it first. They got the trademark. And then he went to file for his trademark. Okay. And when he went to file for his trademark, the USPTO said, hey, hold it. That's likely to be confused with this other trademark that already exists up in New York that he predated. Right. And so he hired me, and I was able to come in and negotiate that. Basically, the other side was like, oh, yeah, your trademark our trademark predates yours. And I'm like, no, try again. And eventually they agreed to what we call a coexistence agreement, which is basically where both sides say, no, look, we're in these two different fields. We don't think that there's going to be any danger of overlap. Please let us use these marks, even though they're similar enough that you think there might be confusion. Please let us use them anyway. And then the trademark office still has to accept those. Sometimes, even if both parties agree, they won't accept that. But in this particular instance, they did, and so he was able to get his trademark to go through. Even though
I've got to share. This is going to be changing gears a little bit. I've got to share Ryan's question here. Mr. Hunk Lawyer Guy, I 1099 all of my employees so I don't have to pay any overtime or their taxes. They're also on a salary. My accountant says it's totally cool, but one of my employees claimed employee status and now IRS is going to audit me. Is this my employee's fault or for my accountant? I don't have any money to pay anyone. P.S. Hi, Dougie. So, and I know Ryan is doing this in fun and in jest, but we really do see situations like this.
Absolutely.
In our industry all the time. Oh, well, I'm 1099ing the guys, so I don't have I don't have to do this. Or they're on a salary. It's crazy. And I wish people would get a basic understanding of business. Because they really don't realize what liability they're putting themselves at, and
very much so.
They can lose everything they have by trying to game the system, or just not even trying to game the system, but just not doing stuff the right way.
I was going to say, in my experience, usually people aren't trying to game the system; they just don't know the system, right? Like one of our clients the other day comes to me with a piece of paper and is like, "Oh, what's this?" And I'm looking at it and I'm like, "This is a notice of tax lien." This is not good.
This is something serious.
This is not good.
That has a little bit of teeth.
I mean, I'll give you a great example from the other side, from like one of the things that we hear about all the time. Guys who are using the corporate checkbook, the corporate bank account as a personal checkbook, and going to the ATM and taking out $200,000, $500,000, whatever. Then they get a workers' comp audit. And the workers' comp audit basically wants to have an accounting for all kind of cash monies that are spent out of that account. And if you don't have a good explanation for where that $500 withdrawal went, they wind up back charging you for workers' comp. And I have heard multiple stories of $2,000, $5,000, $7,500, dollars in additional workers' comp that people have had to
get rid of those shortly.
Yeah,
they take workers' comp pretty seriously. Yeah.
Yeah, they do.
Okay, so to answer this particular question without answering it too much, because again, right, facts vary, different situations vary. You don't have the money to pay anyone. See, I mean, I understand what you're saying, right? I really understand what you're saying when you say you don't have the money to pay anyone. But I really also think that you don't have the money not to pay someone.
Yeah.
Because that's going to hurt more, honestly, in the long run. That is going to hurt more.
And Ryan actually has an amazing business. He is just cutting up. He's having some fun.
But he's bringing true real life stuff.
True things that happen in our world right here. Okay. So James, I need this guy.
He'll get you his contact info.
Yeah.
Okay, so to answer this question, so every state is different. Okay, different states have different rules on what counts as being an employee versus being an independent contractor. And then the IRS has its own rules too. Some states just say, follow the IRS rules. That one's nice. That's simple. I like that one. Except that the IRS rules are like, consider these 12 factors. And then some states, like California and actually Virginia recently, have adopted more expansive rules. Okay, so in Virginia, at least, they passed in 2020 a rule that basically said if you as an individual are providing services to a business, then you are assumed automatically to be an employee, not an independent contractor, unless one of you proves otherwise. Okay, which is, I mean, California is even a little bit worse. That's why my understanding is Uber doesn't operate in California, because under the California rules, they couldn't find a way to argue that they were independent contractors and not employees, which of course made Uber's entire business model untenable in California.
Right.
So California is busy sinking itself into the sea, and not just geographically, but the Virginia. But there are some other states that are starting to move that direction too, and it's and so it is a state by state kind of a question. Plus the IRS, right? So you could get in trouble with the state, but not the IRS, or vice versa, or both. Hopefully neither. But
Nick is saying that happened to the place. This is going back to the names. They settled and told us if they operated out of Florida, they would have to operate under a different name.
Mm-hmm.
I mean, let's see.
And look, just so everybody's on the same page here, just because your city and state approves your business license and EIN number doesn't mean that you're not infringing on somebody else, because they may already have that. And especially we see a lot of companies that use the same. So backing up and getting a little bit on track or off track. Back in the old days, we used to use what? We used to use the yellow pages, and many businesses would be AAA pressure washing, because they would do that so that they would show up first in if you're looking at pressure washing, you go to the pressure washing page, the very first one you see is AAA pressure washing. So they would do that, right? So nowadays, that's completely different. Everything is online for the most part. They still have yellow pages, but everything is online. So if you're typing in a specific name, if you're using the same name as somebody else who is so many miles away, it's not going to matter, because it's all the same theoretically when you get to an online venue, kind of thing.
And that's exactly it, right? Let's say you've got you have your name, they have their name. Even if neither of you has a trademark, right? Then there could be problems. There could be problems because someone could search for one and find the other, or whatever. It really is easier to just find a name that nobody else is using.
Mm-hmm.
Yeah.
I
had a young man in the office today, and I was like, "What are you going to call your company?" And he said a name, and I said, "Can I show you something real quick?" And I went to the Florida Division of Corporations, which in our state, that's where you go and register your LLCs. And I said, let's look up precision wash or something, or precision power washing. And there were, 15 different. One, he's like, well, look at this one. There was 5 pages, and it was a pretty innocuous name that could have been used for a maid service, a car wash, a pressure washing company. But there were literally 5 pages of active and inactive corporations. And I said, you want my gut feeling is, don't do something that everybody else is doing here, because it could lead you to problems, down the road in my completely non-legal capacity that you're asking me this question here.
I mean, it's true. So our firm can set up LLCs in any state. Okay, we can do all 50 states. And when we go to set up an LLC, one of the first steps that we take is always a trademark search. Not just like a corporate name search, a trademark search, because we want to make sure that name doesn't cause problems down the road, right? It's far easier to change the name of your company before you get it started than after. Exactly. Especially once you start spending some money on advertising, you start spending money on all of these things. It really is easier to check ahead of time. I have seen a bunch of clients not do that, and it costs them a lot of money later, because then they have to pay me to beat off all the trademark infringers with a big stick, and
or to recoup your Facebook page or whatever the case may be.
Well, that's what I mean, right? Like one of our clients has a trademark on a name that is apparently just really popular for construction companies. Really popular. We've found like 40 different infringers, and all over the country, right? Like, and this is not even, I haven't searched every
they don't
state.
even know they're doing it.
Yeah. I've just searched some of the states, and just the states that I've searched, I've found like 40 infringers, and he owns the trademark. So I have been going around. I have literally a retainer account with him, right? Where he just keeps money on file at all times. And if he finds someone he wants me to zap, I go out and I zap them. It's gotten to the point where we don't even try to take them all down anymore. It's just like, okay, who do you want? Like, you want me to pick off the top one on the Google search? Do you want me to pick, like, who are you getting ready to expand into Georgia? Okay, let's pick off this guy, right? It's like, it's a mess. Just pick a name that isn't being used by everybody.
So this one here, Jesse is asking, what would you say to someone that is looking to open shops in 2 different states? Main shop in one state and open 2 more shops in 2 different states? How would you suggest that they open up? I would think that they would open up under the same name. Maybe not.
Okay, so in terms of branding, I mean, you're still, it's more than just a legal question. It's also a business question, right? Do you want to be known by a different name in every state or in some states, or do you want to be known by the same name in all states? If you pick the right name, right, you do a trademark search or whatever, you pick the right name ahead of time, hopefully you don't have to be known by different names in different states. You can just be the same thing. Now, if you don't search ahead of time, sometimes that can actually block you from being able to do business under that name in that state, right?
Because somebody else already has it.
Yeah, I had to give a client bad news the other day because they were doing real estate deals in North Carolina. And as it turns out, in North Carolina, at least as far as I can tell, after the letter we got from North Carolina, I'm not a North Carolina lawyer, but I can read between the lines. And when they deny your trademark, they basically said, this person owns an LLC by this name, therefore you can't get a trademark on it. So in North Carolina, at least, having an LLC by that name is good enough to get you some trademark protection, which different states are different, right? But holy cow, I had to immediately turn around and tell our client, if you keep operating under that name in North Carolina, this other company by the same name could potentially sue you, and you're in real estate. We're talking potentially millions of dollars of damages.
Mm-hmm.
So
there's a similar question. Hold on one sec. There was another similar question to that right here that Rob asked. Are domain names treated the same way as trademarks?
That's a good question.
That is a really good question. Thank you for asking that question. So a domain names are harder to protect. Well, sort of. With domain names, possession is 9/10 of ownership. If there is a domain name that you are even thinking about having, if there is a trademark that you are even interested in filing for, buy the domain. Buy it right away. Don't wait. It's not that expensive, and it's a whole lot less expensive than if you failed to get it.
It's $10.
So,
yeah, sir. Yeah.
So if you have a trademark, okay, sometimes you can get a domain name based on having the trademark if it's a really good trademark. Okay, so what do I mean by that? If you have a domain name that's like Phoenix Pressure Washing, right? That could mean any company, any pressure washing company in Phoenix. So just having a trademark on Phoenix Pressure Washing wouldn't necessarily be enough. And you probably couldn't get a trademark on Phoenix Pressure Washing anyway, by the way, but I'll come back to that. You wouldn't be able to say, well, I have a trademark on Phoenix Pressure Washing, therefore PhoenixPressureWashing.com should be mine, because the other guy could just say, well, I'm not talking about the location, I'm talking about the bird. And now he's maybe not infringing your trademark, right? Now, on the other hand, if you have a trademark that is really distinctive, as in it's a made-up word like Xerox.
Spray wash.
Sure. Or I don't know. Yeah, sure. Whatever.
Mine was Cajun soft wash. I would think I would have a better chance than spray wash because
yes, and like that's what I mean.
We spray wash your house.
The more distinct your trademark is, the less likely it is that someone else is going to be able to say, "Oh yeah, I got this domain and I didn't realize it was someone else's trademark."
I went and I actually had a similar. See, I owned a fairly decent sized pressure washing company here in Tallahassee, Florida, and named it Spray Wash. First started using Spray Wash Exterior Cleaning was the true LLC name on there, but it was we did a DBA by Spray Wash, and about 4 years ago, someone decided that they were going to open a company and call it Tallahassee Spray Wash. And we were, like I said, we were a good sized company for that. And, we have an attorney and we pay 5 figures a year too for just really just random crap. And, I said, Terry, what are we going to do here? What should we do? And he said, well, we never really know. We're talking about the law, what's going to happen. He said, but I'm going to give you a percentage base of what this could get quashed by and go probably about 99% of this because he's operating in your area under your name and just has put a geographic location under you. And the term spray wash really wasn't that widely used before you started using it back in 2009. And so we started doing some research into it. And I said, you know what? This is not something to really worry about. And I'm going to save the $5,000 on this and just let nature take care of itself. And nature took care of itself. And that company then went away. And, it wasn't really it was more of a perceived threat than an actual threat. But that's the kind of thing that you could really get yourself into a lot of trouble by doing that and doing it intentionally, wouldn't you say?
So the damages for intentional trademark infringement are what they call treble damages. Okay. That's basically a fancy word for triple. You can get triple the amount that the other person made by infringing your trademark if you can show that it was a willful infringement. Okay. The law does not look kindly on people who intentionally try and steal someone else's trademark and use it. Now, obviously, there is the question of, can you get blood out of a turnip?
Yeah.
But because usually the people who steal your trademark are the ones who have no money.
Nothing.
Because they
it's funny how those two go hand in hand usually,
Well, I mean, is it the lack of morality that leads to the lack of money, or is it the lack of money that leads to the lack of morality?
Potato, yeah.
Yeah, develop your own theories. But so I do want to comment on one other thing that I've seen. I've been kind of watching the comments a little bit, and I have seen a couple of comments that I want to add one detail about trademark. Trademark is not just a protection of your brand on a specific name. It is a protection of something. Actually, let me. Here's the legalese. Okay, a non-functional attribute of a product or service used. I think it's used to display the origin of the product or service. So basically, the idea is, one, it has to be non-functional. Okay, so if you can't trademark a box because the box that you were showing earlier, right? You wouldn't be able to trademark that because it's actually functional. The shape of it isn't just a design choice. It actually affects how the device functions.
And that's where the patent comes in. That's the patent protection.
Right. So a trademark is just a non-functional attribute. It's decoration, okay? Now, it doesn't have to be a logo. It doesn't have to be words. It could be, so the shape of the, you guys remember the shape of the glass Coca-Cola bottles?
Mm-hmm.
That's trademarked. The reason you never see anyone else with a bottle shaped like the Coca-Cola bottle,
yeah, interesting.
It's trademarked. The roof of Pizza Hut, the shape of the roof for Pizza Hut is trademarked. Yes. The color brown with package. If a truck pulls up outside to deliver packages and it is brown, I don't have to tell you the name of the company. You know which company I'm talking about.
Interesting.
So, trademark is an attribute. It doesn't have to be a logo. It doesn't have to be a name. It's any attribute of the product or service used to show where the product or service came from. Okay. Now, it is tied to a specific good or service or set of goods or services. So, you can trademark Apple with computers. You cannot trademark Apple with a fruit stand. You could trademark, let's see. So Mustang, right, is a kind of horse. It suggests what it is. It's a vehicle, right? But it doesn't actually outright say it. Trademark is this kind of seesaw, okay? You cannot get a trademark on something that is only descriptive. So you can't trademark pressure washing. Why? Because all it does is say what you do. You can get a trademark. The more distinctive something is, the easier it is to get a trademark on it. The more descriptive something is, the less easy it is to get a trademark on it, but the more useful it is in your business because it actually tells your customers who you are and what you do. So there's kind of a seesaw there where you want it to be descriptive enough that people know what you're talking about, but also distinctive enough that you can actually distinguish yourself from everyone else and protect your brand. Okay. There are a couple of different ways you can do that. One of the, in my opinion, better ways is to have a name and then a tagline. Right? So you can trademark.
So you're saying something along the lines of like, I'm trying to think of it. It's right there at the top of my head.
So my gold standard example is Xerox. They made up a word. It's hard to get much more distinctive than that because the word didn't even mean anything until they came along. Now
you're in good hands. That's what came to my mind. You're in good hands.
Okay. There we go. So that's probably trademarked too.
Mm-hmm.
Okay.
So on this though, how about this one by Rusty? What's the difference between a trademark and a service mark?
So they're almost the same thing. A trademark and a service mark are both the same law, right? Just applied to goods versus services. So a trademark protects goods, a service mark protects services, but usually people are a little bit sloppy with the language, and so we just say trademark, good or service. Technically, if you want to be precise, right, it's a trademark applies to goods and a service mark applies to services, but usually people will just say it's a trademark.
So Henry is asking a question here, and he's like, who's copywriting Seminole pressure washing first? So I'm in Tallahassee, Florida. And
I don't think you can get a trademark on that.
Yeah, and so we have, the Florida State Seminoles on there. It'd be like somebody in Gainesville with the Gator pressure washing, or Virginia Hokie pressure washing or something. And it'd be very hard, I would think, to to actually pressure wash a name that would be synonymous with a school, or there's so many. There's Seminole Heating and Air Conditioning, Seminole. Yes.
Tacos.
So let me walk you through the basic trademark application process. When you first are putting together the trademark application, hopefully you have a lawyer who knows what they're doing. They can help you, give you the best shot at succeeding and making it all the way through.
And to interrupt you one time real quick, Roland, you can operate throughout the U.S. on that side of it.
Yes, on trademark, it's federal. I can go anywhere in the U.S. on that. So the firm can go anywhere in the U.S. on that. And we can do business formation also anywhere in the U.S. And then some matters we can work on any state. We can work on all matters in Virginia, Maryland, D.C., Pennsylvania.
Gotcha.
So, okay, so trademark procedure. Once you file, okay, there is a waiting period before an examining attorney even picks up the application. Okay, it just sits there. Used to be for 3 months, then COVID happened. Now it's like 6 months, but it just sits there. Okay, nothing happens for a long time. So trademarks now can take like a year to get a federal trademark because of the backlog and all this stuff. So it sits there for however long the waiting period is, and then it's assigned to an examining attorney. The examining attorney looks at the application and says, does this meet the requirements, the minimum requirements for a trademark, and do we see anything wrong with it? Okay, so not only are they looking to make sure that it's not merely descriptive. Okay, merely descriptive is not good. It's like the kiss of death. They'll come back and they'll say, "Oh yeah, your copyright, your trademark on pressure washing, right? It only describes what you do. There's nothing distinctive in it. It's rejected." They can come back and they can say likelihood of confusion. Okay, we see that we saw another trademark out there that does something similar to that looks similar to what you have. Okay, sometimes it's very similar or identical. Sometimes it's not that similar. Okay, the test is not, is this an exact match? The test is, does the trademark examining attorney at the office think a consumer could be confused between these two marks? Okay, that's a much broader field of protection than you might think, because we've had, I've had a client apply for a trademark on black fin and get rejected because there's a blue fin out there. Okay, I've had a trademark, we've had a client apply for a trademark on Epic Pilates and get rejected because there's an Epic Yoga out there. Oh, these two companies provide similar services. One person might think that the one is also providing the same services as the other. And of course, our client comes back and says Pilates and yoga are not at all the same thing. But I'm like, okay, well, how do you want to prove that to the examining attorney? So, but it's also more obvious stuff, right? We had a client who tried to sneak one through. He or she, I don't remember which. This is actually a story that my managing attorney told me. This wasn't a client I handled, but they tried to apply for a trademark on a restaurant, Celia C's. Okay, and as it turns out, if you remove a space, that's celiacs. And so it was basically, they were trying to say, oh yeah, we're gluten free or whatever, and it got rejected because it's like, no, you can't trademark that word. You can't keep other restaurants from talking about how they're celiac friendly.
But God, right? You got to give them points for creativity, though. That's amazing. I mean,
yeah. So a trademark, it's not just like, is this an exact match? Yes or no. It's like, could someone mistake you for this other company? And that's a lot broader, but it also still has some limitations because it can be a different field, right? You could be, there's an Apple computer, but there's also an Apple Federal Credit Union. There are Apple used cars. There are all these other, I'm sure there are more Apples out there too. And so it depends a little bit also on that. Anyway, so processing, so the examining attorney looks at the trademark. They see if they see anything wrong with it. If they do see something wrong with it, they will issue what's called an office action. The office action will come to the attorney of record if there is one. Otherwise, it comes to the person who filed for it. But, well, really, you get both of them get it. But it's important that your attorney get it, or that if you get one, you probably want to take it to an attorney. Because the office action, some of them are really simple, right? Some of them are just like, oh, is this a, you know, this is not a street address. This is a PO box. Please provide a street address. Easy. Okay, great, fine, no problem. On the other hand, it could be one of those kiss of death kind of scenarios, right? Like this is merely descriptive. This is geographically descriptive, only merely geographically descriptive. This is likely to be confused with, like, insert 5 trademarks here. That not good. But in any case, let's say that you make it past that. Nothing happens. The trademark examining attorney says, okay, I'm satisfied with this one. Let's move it along. The next step is something called publication. Okay. There's a trademark gazette out there that the USPTO, the U.S. Patent and Trademark Office, publishes. I believe it's monthly. But they put out all the trademarks that are being applied for this month. And there are some big companies out there that have enough money to basically just pay a lawyer to sit in a room and look through this gazette and see if there are any trademarks in there that look threatening. BMW, for example, right? They might have a lawyer just sitting in a room who can flip through the gazette and see, okay, I don't see any trademark. Whoa, that one looks a lot like our logo. Let's talk to this guy, right? And so the publication step is what you would have to worry about probably if you tried to trademark Seminole pressure washing, right? Okay, yes, your trademark is in a completely different field. It's not technically, it has nothing to do with the school. It has nothing to do with that. But in all likelihood, that school probably has a lawyer who's watching out for someone trying to hijack their name, their brand, and that lawyer is going to file an opposition, right? They're going to, the publication procedure has a place where you can file oppositions. And if you file an opposition, everything stops, and now it's like a mini lawsuit. The two sides start to argue about, like, okay, should this trademark be allowed to go through or not? Most of the time, an opposition does not happen. Okay, like 99% of the time, when an opposition is going to happen, usually you can see it coming a mile away. Okay, a mile away, because if you're trying to get, like, I don't know, one of our clients tried to get a trademark on Praha beads and jewelry. Okay, Praha is the local language for Prague. So they were Czech style beads and jewelry, and she wanted to get a trademark on Praha beads and jewelry. Well, guess who had something to say about that?
Prada?
Ever hear of a company called Prada? Yeah. So usually when you can see, when you expect oppositions if you get too close to something else that's already out there, right? Most of the time you don't have to worry about it. Most of the, if the client puts in even a little bit of creativity, you can avoid having to deal with oppositions. But if they're trying to be tricky, if they're trying to be slick or cute or something like that, it could happen.
Don't do that. Yeah. Don't.
Yeah. The bigger the mark that you're getting close to, the more likely it is that you're going to run into problems. Yeah, so then opposition, once it gets past the opposition stage or the publication stage without any oppositions, then you're pretty much golden. Then okay, it's going to take them another like 11 weeks to issue the trademark. So the whole process can take about a year. But once they send you the certificate, now you have a registered federal trademark. Now you can do all the fun stuff. You can go and threaten to take people's Facebook pages down. You can do all of this stuff. So you can use the little circle R next to your logo.
Right. So Tiff there said, I live in Georgia, filed his own LLC with Secretary of State and paid my fees and annual renewals. Should I have hired you instead of doing it myself?
I mean, if you can do it yourself, then you can do it yourself.
Some states make it very, very easy, Tiff. Yeah. You know, I mean, Florida makes it so easy to file an LLC. But, you know, it's whenever you start getting this
a lot of it can be done online.
Yeah.
Where we provide
the technical, the trademarks, the copyrights, then get a lawyer. Don't do this stuff yourself. I mean,
where we provide help is not so much necessarily with just the LLC. It's more with the expertise around it, right? We don't just get you an LLC. We also get you an EIN. We also do a trademark search on the name before we set it up. We also put together a basic operating agreement, which most banks will want to see an operating agreement for your company before they will open a bank account for it. And, you know, we can also, and then that way we can answer other questions along the way. Someone said, they ask, so, hey, it's not just me. I'm going to have like 3 business partners. Oh, okay. Example, actually. I had a potential client. They didn't end up hiring us. They're lost. But there were 4 brothers. Okay. There were 4 brothers from a family who owned some real estate here, and they were some of them at least were getting ready to move to Texas. And they wanted to put their rental real estate into an LLC before they moved down to Texas. And I'm like, okay, sure, no problem. We can set up LLCs. We can put the property into it. How do you want to own this? And they're just like, oh, yeah, we're going to all own the company that owns the real estate together. And I'm like, okay, are you planning to have a negotiated operating agreement? Okay, negotiated operating agreement also goes by the name buy-sell agreement for some people in some states. So are you planning to have a negotiated operating agreement? And and you can always tell when there's trouble because they ask, the first question is, well, how much is that? Mm-hmm. Like, this is kind of important, guys. So how much is that? Oh, well, it's this amount. No, I think that's okay. We can figure it out for ourselves.
Well, we'll all work it out. Yeah,
we'll work it out. Well, no, it's okay. We all like each other. We all get along. I'm like, yeah,
we're family.
The problem is until you don't.
What could go wrong?
because right, we can. That's what. So a negotiated operating agreement sets out what the company, what all the power, what you can do and can't do with the company. Okay. It sets out, here's how we add people. Here's how we take out people. What happens if one of them wants to leave? What happens if one of them wants to sell? What happens if one of them dies? What happens if one of them gets married? Do you want the wife to also have a say in the management of the company? What happens? You know, there are a lot of different little things that people don't think about when they're starting their company. And we have done this enough times that we can go through there and ask them, so what do you want to have happen if this happens? What do you want to have happen if this happens?
We did that at our company because we had grown to a point where, you know, we were at 7 figures on there and had kind of a juggernaut company on there. And our business attorney said, look, this is something that you need. I mean, we need to devise a way for this to continue on in case something happens to you or your spouse, you know, together, and who's going to get what, in fact, Doug was, you know, at that point, you know, Doug, if you remember, I actually put you in there. You and Tim were going to be running my company. Right. Y'all were the remainder men on there, you know, with the assets going to the kids. And these are things that we do need to think about, you know, in our businesses, especially when we get traction and we get growth. Because what's what's the point of growing this company and getting up here to a $500,000, $700,000, $800,000, $900,000 company, and then not doing and I know we're not doing trademarks here, but doing this work and then having it fall apart at the end because of your death or incapacitation and not having the right legal stuff done?
Yeah, especially in a case like, I mean, if you have an accident or whatever the case may be, and you are now incapacitated or killed, and what happens to your company? So that is something I don't know if you know Ray, but I did the same thing. So I put Ray as the person that would take over and be able to, guide the company into a sale or into whatever it wanted to have, whatever needed to happen.
Running for a little while. Let's milk a couple $100,000 out of it. Yeah.
Mm-hmm. So at least in Virginia, Maryland, DC, Pennsylvania, we can also help entrepreneurs with succession planning. Okay, some entrepreneurs, if you have a will or trust or something like that, right, you may not have integrated that with your business plan. Your business might say one thing about what happens if someone gets incapacitated, and your will might say something else. You want those to kind of work together too. So that's also, so we don't do a lot of wills and trusts and estate stuff, but we do for entrepreneurs, right? We do try to help them integrate those things with their business and their operations too.
So Roland, I've got two that have kind of popped in mind.
Before you do that, keep in mind that we are almost an hour and a half into it. We're gonna have to let him go.
Sorry.
Before you ask your question, Ray.
No, I don't want to let him go.
Let me ask you this: would it be something you'd come back maybe here in a couple of weeks, and just as a thought? I shouldn't ask you that on the live. I'll ask you that.
Yeah, you ought to see how many calls he gets tomorrow from customers, and I
don't even think we touched on our subject that much. But anyhow, go ahead, Ray. I'm sorry.
Well, I want to give Mr.
Roland
this, but I think it's food for thought if we have another discussion. But I see two things out there. What's the liability of someone if they hire an independent web designer? Because we saw this happen last year at, remember one of the other forums, Doug? And the owner of the forum was selling websites, and he was out stealing pictures from the internet and doing websites for pressure washing companies. And the pressure washing companies had no idea that those were stolen photographs until they started getting,
And another great example of that, I trademarked Cajun Soft Wash, but we had several times this happened, but we had another company that specifically their designer took my logo and kind of redesigned it a little bit.
Right. I'm going to put 3 claws on the crawfish instead of, instead of just 2. And then the other one that I wanted to speak to for a moment is I see in a lot of these forums where these designers, you used to go out to Fiverr and get a logo made or call a professional out there, and guys are going, let me make you a free logo. I'll take donations for this, but let me make you a free logo. And they're using boilerplate logo junk. I mean, I don't mean to insult anybody's work, but they're using boilerplate logo stuff. It's literally the same thing. What's that?
If they're copying somebody else, it's not their work.
Yeah, I mean, but they're doing a logo, and it might say spray wash with the same house peak, and then it would say Cajun Soft Wash with the same house peak on there. So it's not really a custom logo.
So you're not going to like to hear this, but if this guy, this graphic designer goes out and he steals someone else's picture and he puts it on your website, it doesn't matter that you didn't know.
You're still liable.
Really?
Yes, they can still come after you for trademark. Now, if you have a good contracts attorney, then the agreement that you have with the graphic designer will say you agree to indemnify and hold harmless for any copyright infringement that you may commit, right? And then any damages that are levied against you, you can now go after the graphic designer for. Of course,
so this is important for all you guys out there getting free logos.
That's a topic all of its own right there. That is super.
Yeah. But all you guys out there getting free logos, or I'll do your logo for you for donation. If these people are just you could gain some huge problems there.
I want to do this. I know that we've taken up a bunch of your time. I knew that you were ready to get off. And we so greatly appreciate you for coming on. We will invite you back. Hopefully you'll want to come back. Hopefully you've had a good time with us. I want to end something with this too. Landon was a good reason for this happening, and he is a client of yours. But Landon also made a post today that I want to. I think it is what we are, Ray and I, over there. And look, in the whole branding thing and all this, I just want to say, be a man of your word. That is what Landon posted today, and that is, I think, something that we're missing in today's world. And all you have to do is do what's right and be a man of your word, and everything should be fine after that. Quit stealing, plagiarizing, blah 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 blah, and you should be fine in business. Protect yourself by getting the advice of somebody like Mr. Roland here. And Mr. Roland, we'll leave it to you. You got any parting words for us?
No, I think that's it. Thanks for having me. I kind of still want to answer the other
go
question.
for it. You got to go for it.
I'll hang out all night. I mean, I love this.
As much time as you got.
Okay. Wait a minute. What was it though? Okay, copyright and the man.
We have the guy stealing photos, the web designer stealing photos, and then we have the
yes. Okay. So I let's see. So I have a little quiz. Okay, I have an illustration example teaching quiz thing. Let's say that you want to. You want to create a brand, right? You're just getting started. You have a brand you want to protect. You go out and you hire a web designer. You hire a graphic designer. Someone. Let's say you hire a graphic designer, right? They're going to create a logo. They're not just going to copy something. They're actually going to create it. When you do that, what rights are you looking to get from them? Copyright or trademark?
Yeah.
Pop quiz. Anyone want to take any guesses? Or maybe not just guesses?
You'd have to ask me the question again, because I was actually on another thing looking at something. Okay. So what was the question?
You hire a graphic designer to create a logo for you.
Right.
When you hire them to do that, what you're buying from them, is it a copyright? Is it a trademark? What are you buying from them?
Well, I think it would probably be a copyright, but you would have to turn it into a trademark. And you also need to make sure that when you're setting up, you're hiring them, that you have a contract with them that then turns that over to you as a legal right, because otherwise they own possession of it unless you have some sort of contract that makes it your property.
That is a really accurate answer. That's good. Okay. Yes. So that's right. When you hire them to do that, you want to make sure that in your contract, you say, this is a work for hire, right? This is a work for hire. And therefore, even though you're making the copyright, I will own it. That's basically what you're buying from them. You're buying the copyrights because they are creating it. It's an artistic work, right? Fixed in a tangible medium. They create it. They sell you the rights to it. Then, yes, you turn around and you say, I'm applying for a trademark on this graphic. This graphic that I now own the copyrights to is my trademark. It is the brand by which I will be known. And then you have both rights, right? And if you ever go to sell your company, you're selling both. You're selling the copyright, you're selling the trademark, because you own both. And you want them, and the buyer will want to have the right to reproduce the logo, which is a copyright thing, but they'll also want to have the right to use the logo to advertise their product or service, which is a trademark thing.
Mm-hmm.
I have also seen on a similar piggyback to that, where guys and gals have invested amazing amounts of money into their website, in their website design, only to find out that they don't own their website. They don't own
they don't
the
own
content of their website, and the designer owned their website. And then suddenly the terms of the agreement became untenable and they were unhappy with the service. And it was essentially, okay, start over, but I own this. This is mine, at what the designers told them.
You also have to remember out there,
do the contract.
if you hire a designer and he says, I'll get a website for you, I'll get the domain name, I'll take care of everything, I'll put it on my servers, all of that. If they go out and they purchase that domain name for you, they set everything up for you, they've got the back, you have nothing. You're indebted to them forever and ever. Amen.
Well, I mean, yeah, whether you technically own it or them, I mean, practically speaking, how are you going to, if they decide to make off with your website, what are you going to do about it?
Exactly.
Right.
If they want to turn your access.
I'm all for the legally speaking. Yes. The who owns it. Yeah. Okay. Yeah. But practically speaking,
Right.
what are you going to do? So, yeah. But
Also,
yeah.
what do you think about the importance of a tagline? So like spray wash or you know, whatever it is to help solidify your mark. And again, let's go back to what you were saying about Xerox, or you know, that you're in good hands, you know, throwing that slogan on there to solidify your trademark.
So you make the logo distinctive and you make the tagline descriptive, right? Mm-hmm. Argent Place Law, Circle R, the law firm for entrepreneurs.
And that's the tag.
Now they know what you do,
mm-hmm.
but it's also very distinctive. It's unmistakable, and it's clearly something that it's like, okay, there's nobody else out there by this name.
But now what if I say the law firm for entrepreneurs, but Burke Law?
Well, then it depends on whether we've trademarked the tagline or not too, right? Because if we haven't, and who knows, you might not be able to trademark that, right? Because it's merely descriptive. It talks about what you do. But yeah, you might be able to also say the law firm for entrepreneurs. And that's actually kind of trademark law working as intended, because you don't want the trademark law, right? The USPTO, the Constitution, all the people who wrote the law do not want you to be able to block other people from saying what they do.
Mm-hmm.
Right.
It's kind of the same thing with employees, where you have your agreement and you put into your agreement that they can't do what you do. You're going to teach them something, right? A non-compete agreement, right? So it's kind of along that same line, where you can't really prevent them from working later on.
Non-competes are illegal in a lot of states now.
Yeah.
You'll want to, check with a local lawyer, but at least in Virginia, for example, non-competes are getting really hard to enforce. DC, it's next to impossible. And I don't know about other states, but there's also been this movement towards having non-competes. Like the only place, in DC at least, the only place where you can still do a non-compete is like if you're a medical professional making more than $400,000 a year or something like that.
Florida's all right to work state, and it really makes it tough in Florida to enforce a non-compete. You know, I think of a thing like, you know, what is it? That large, I don't even know if I'm allowed to say it or not, but that large football game they play once a year in January between the, you know, the one for the national championship, and where, you know, you can't go and like, unless you're a sponsor of them, you can't use those words in your advertisement because they have those two words on lockdown, you know?
Yeah.
You can't go and say, hey, you ought to buy our chips for your blank party.
Yeah. Well, and it might, remember, just because something is unenforceable doesn't mean that they can't try to enforce it.
Right. Yeah.
In some cases, like when you're dealing with a $9 billion franchise, right? They might have the money, or 9 billion. I think it's about 9 billion. They might have the money to just
and they have the lawyers on staff, so
they lose in the end, but by the time they lose, your ass will be broke.
Exactly. Like they can throw lawyers at the problem.
Right.
They absolutely can just throw lawyers at the problem. And okay, yeah, is it enforceable? Who knows? But you'll never find out, because before you ever get there, the cost of the lawsuit is going to sink you.
Right.
So
exactly.
You'll be 90 years old before it even gets settled out.
Right.
That they can drag those things out
if
for a
you
long
have
time.
enough money to even last that long. Yeah.
I mean, copyright and patent trolls are a thing, right? There are these companies and firms out there that just go around, hey, we have a patent on this thing and on antennas, right? Yeah. And you, Mr. Small Coffee Shop, you're using an antenna in your Wi-Fi system, and therefore you're violating our patent. And we've already filed a lawsuit, so you're going to have to hire a lawyer to stop us, and it's going to cost you at least $5,000 just to deal with that. Or you can settle, you can pay us $2,000, and this will all go away.
You know, I mean, it's crazy through my friend's patent that he's pursuing. You know, he's been contacted and recommended by his, you know, and it's a fairly good patent firm that he's working with, and a really good patent attorney. She's sharp as a tack. But, you know, hey, whenever this does eventually, you know, if this happens, when this happens, here are the enforcement attorneys that, because these are going to be federal lawsuits, and these guys work for just a percentage of collections on there as well. And there's guys that are kind of lining up to go, yeah, we really would like to represent you in this matter, because we see the potential of this, and this is kind of huge.
So
and that's not the only place, but yes.
Just to go over something one more time, because I think this is super important too, where you had said, like to begin with, when we start thinking about creating a business name, or we have a business name, just Googling it and trying to find out, that's not the right way to do it. You actually need to do a trademark search to see if that is trademark, because Googling it may not bring up what a trademark can do. So what is a good way to do that? What is a good way to do a trademark search with or without an attorney? And then one thing that you think we should have asked, or that the group should be asking, that we didn't ask.
Okay, ideally you would do both, right? You would do a trademark search and a Google search, because there might be things that would show up for one but not for the other. If you could have a situation where, right, nobody has trademarked the word, but as it turns out, 40 construction companies are using it in their name. Right. So you want to do both, ideally. But if you don't have the money to hire an attorney, well, okay, if you want, you can hire a law firm to do a company formation. If they include a trademark search like we do, you can hire a law firm to do a trademark search. What we prefer to do is actually you pay us for a trademark, and then we just kind of, if we have to, you give us a list and we cycle through them and find one that'll work, right? So we kind of charge not for like one trademark on this, but one trademark until we find something that'll work for you, unless, of course, you have like one specific thing that you really are attached to, which is a dangerous move, by the way. If you get attached to a brand before you know that it's yours, careful. So if you want to trademark search yourself, you can. Okay, there is a tool out there, TESS, T-E-S-S, the Trademark Electronic Search System. It's like a search engine for trademarks. And every trademark that's out there is public information. Okay, anything and everything that is filed about every trademark is public. Okay, double-edged sword there. Everything is public. I can go look up another person's trademark at any time. I can see the entire history of it. I can see every objection that was raised during the application process. I can see what specimens they used, what examples they used, what their logo was. I can look at everything in any trademark that I want to, and so can everyone else. So you can also use this tool. I would say the big difference is, right, if you use the tool, you're doing it probably for the first or second time. If you hire someone to use this tool, you're hiring someone who has used the tool hundreds, thousands, maybe more times, and knows not only how to use the tool better, but also what kinds of things are iffy and what kinds of things aren't. Right? What kinds of things are close? What kinds of things are not so close?
Right.
So,
I mean, I can go out and buy a DeWalt circular saw at Lowe's and cut a 2x4. But at the same time, I can hire a carpenter who can actually build something and put it into square and frame a door out where whatever I build is going to look like that. It's sometimes. So it's the same thing we're doing in this business. Hey, hire a professional. Yeah, all of you guys, you can go buy a pressure washer, but if you hire me, I'm going to make sure I do it right. And exactly.
And so it's the same idea with the trademark search. So you can, if you don't have the money to do a trademark search right now, I understand. Okay, you can go do a Google search, go do a test search. Look for things in tests that are not just exactly your mark, but also similar to it, right? And hopefully you don't find anything. If you don't find anything, that means there's nobody else out there using it. And it's still not a guarantee that you're going to be able to register that, but it probably improves your chances by a whole lot.
Gives you a good start. Mm-hmm. So what is one question that you think that we should have asked, or us or the people that are watching? What is a question that we haven't asked that maybe we should have asked?
Yeah. Yes, Rusty, I agree. DIY this stuff can be dangerous. Okay, let's see. Protecting a brand. Oh, okay. I will give one other fairly common situation. What about variations? Let's say you have a logo, or okay, let me back up first and say it this way. Any change to a logo changes the mark. It is a different trademark. Okay, so what I see, one of the most common mistakes I see with a trademark is that someone comes to me and they have 2 or 3 or 4 different versions of their logo, their brand, their whatever, right? They spell it one way over here or a different way over there. They have one of our clients had J.O. painting, okay? And he had a J.O. painting in one location. He had a J.O. painting in another location. And in a third location, it was J.O. Painting Company, Inc., okay? And another location, there was a typo. Company, comma, Inc. had become Company, period, Inc. So he had about 3 different ways that this logo appeared. I think there might have been a 4th on his letterhead. I don't remember exactly. But each of these was a separate trademark, technically, okay? Or sometimes you see, right, especially with mobile-friendly websites nowadays, you see they've got this logo, and there's like a globe on the left or something, and then some words out to the right. Except on a different part of the website, or in their letterhead, or in their emails, or whatever, the globe is on top and the words are underneath. These are 2 separate trademarks. So, and every time you redesign your mark, every time you move something around, you're resetting your date of first use.
I used to fuss at Tanya about, my wife Tanya, about this, because Tanya is very color specific and very, so she would want our old logo to match whatever she was wearing. So, and our logo was, Pantone 4682 blending into Pantone 4637. I mean, it was very, very specific on there.
That's more
And
specific.
Tanya would go and do, well, this is a red shirt, so I want a white on there going into a blue. And I was like, Tanya, you really can't do that. I mean, you know, and again, we're a small pressure washing company, but
I'm going to close with this. I know a trick works not all the time, but most of the time, so that you can protect a mark so that it doesn't matter what color it is.
good. Because that was the object of several discussions that she and I had, very heated discussions, and I'm like, "This, you're killing our brand. Honestly, you really are."
You can trademark the logo in such a way that you can change colors and they're all protected.
Nice, very nice. Well, golly, I cannot thank you enough. This has been just absolutely amazing. I love good technical advice like this, and yeah, this and our guys that watch this do too. I mean, they really need this information, and I hope this will get you some good calls, and you know, and understand, guys. Anybody who's watched this, and you know, you're on here now at an hour and 50 minutes. That Roland is also an active attorney that does this for a living, and that's why his website and phone number is out here. So you know, please call.
ArgentPlaceLaw.com.
Yes.
So phone number, by the way, is the office number. My extension number is 3.
Number 3.
Yep.
There you go.
Got it.
Because each of the attorneys has their own different role there.
Yeah. I mean, you know, we work as a team, obviously, but each of us also has our own kind of wheelhouses too. So, yeah, thanks for having me, guys. This has been
we greatly appreciate it, and for all y'all hanging out with us this long, we greatly. I think this is actually one of our longest lives.
It really is. It really is.
I think we're hitting one of our longest.
Well, you start going down rabbit holes, and you just got to keep going down them. So,
and
all right,
we covered the
Roland, stick around for just a minute for the debrief. But guys, thank y'all very much for your time tonight. We appreciate y'all, and wash on.
Wash on.